So I'll just give you a brief overview of the OAIC, the Privacy Act, and the Australian privacy principles, and our involvement in data matching activities, and also perhaps give you some privacy guidance and issues and better privacy practice ideas regarding data matching. So just a brief overview, we are an independent government agency. We are the national privacy regulator. We are headed by an Australian Information Commissioner. That's currently Angeline Falk, who's currently acting Australian Information Commissioner. And we also have responsibilities for freedom of information and government information policy. And our privacy function is derived from the Privacy Act. The type of privacy covered by the Privacy Act is information privacy, so it's the protection of individuals' personal information. Personal information is defined in the Act as information that identifies or could reasonably identify you. It also includes sensitive information, and that can include things like an individual's racial or ethnic background, criminal record, sexual orientation and practices, health information, biometric information. The Privacy Act also has provisions to deal with tax file numbers and credit information. There are 13 Australian privacy principles in the Privacy Act. These are legally binding principles, which are the cornerstone of the privacy protection framework in the Act. The APP set out standards, rights and obligations for handling personal information, and they also impose some higher standards for handling sensitive information. The APP is applied to most Australian government agencies, as well as some of the private sector, and collectively those entities are known as APP entities under the Act. The APPs are principle-based law, which means they give APP entities flexibility to tailor their information handling practices around their unique and particular circumstances. And the APPs are structured to reflect what's known as the personal information life cycle. So right from the beginning, when you collect personal information, through its handling, and then at the end with its de-identification or destruction. I'm not going to go through all of these powers, just to say that the OAIC has a wide range of regulatory and enforcement powers that we use to ensure agency compliance with the Privacy Act and to encourage best privacy practice. So the OAIC's guidelines on data matching in Australian government administration defines data matching as bringing together of at least two data sets that contain personal information and that come from different sources, and the comparison of those data sets with the intention of producing a match. Our office recognises the value of accessible data from government and also across government, and that this value is best maximised when information can be shared, reused and built upon, for example through data matching activities. We recognise that data matching can be an immensely valuable resource for policy, planning, research and innovation, ultimately providing better services for Australian individuals. But we also understand and recognise that privacy, or to put it more accurately, personal information protection, is integral to that equation. So government agencies that collect information through an individual's dealing with them, for example, to receive a social security benefit or some type of service, like for healthcare, but most of the time when an individual must provide their personal information, a requirement often supported by legislation. This limitation of choice to provide information means that it is important that government agencies handle this personal information carefully. We don't consider the Privacy Act to be as a barrier to effective information sharing. Instead, we see that successful data-driven innovation in policy and service delivery needs a strong foundation in personal information protection. And so as a result, we are involved in a number of activities in the data matching space. So we provide policy advice to agencies conducting data matching activities. This is mainly done through our voluntary data matching guidelines, providing comments on data matching program protocols, and responding to exemption requests under our voluntary guidelines. And we also conduct privacy assessments, which is very similar to audits in relating to data matching. And we're currently doing a number of assessments in the DHS welfare payment space at the moment. So the OAIC also has an important privacy oversight role in relation to data matching that falls outside of the voluntary guidelines, specifically under the Data Matching Program Assistance and Tax Act, which relates to data matching and tax file numbers, and also under the National Health Act, which relates to the PBS Medicare data matching. So when it comes to data matching, the key document is the Voluntary Data Matching Guidelines. There are 13 guidelines that provide guidance to Australian government agencies to ensure data matching complies with the Privacy Act and is consistent with good privacy practice. The guidelines apply to data matching programs that involve information about at least 5,000 individuals or more. So there is a threshold component in those guidelines. The guidelines do not generally apply to data matching where the tax file number is involved, or where, for example, the NCVER, the Pharmaceutical Benefits Scheme Medicare space, as I mentioned earlier. The voluntary guidelines are also voluntary, meaning so they're not legally binding. However, they represent the OAIC's views on best practice with respect to data matching activities. If one were not to comply with the guidelines, they wouldn't be breaching the law. However, it is something that we would take into account if, for example, at a later date there was a privacy breach or a complaint was made. One of the things we would look at is compliance with the voluntary guidelines. Also under the guidelines, the Commissioner, in appropriate circumstances, can grant an agency an exemption from specific requirements of the guidelines. Exemptions are granted on a case-by-case basis, and it's on public interest grounds, so the agency seeking the exemption needs to make a case as to why they should be exempted from the guidelines. And usually those exemptions involve extending retention periods for the data or to keep the program protocol confidential. We also recommend that primary user agencies evaluate data matching programs regularly, at least every 3 years. We receive data matching protocols, amended protocols, or requests for exemptions fairly regularly, and about 5 to 10 protocols and requests per year. And the guidelines, a key requirement of the guidelines state that you need to prepare a program protocol before you undertake data matching, as well as a technical standards report. I know I have limited time, but basically, essentially, the program protocol and the technical standards report are supposed to essentially set out the details of what it is that you're proposing to do, complete overview of the matching, all the entities involved, the data involved, how you're going to do it, the risks involved, what controls are you going to use for data quality, for security, etc. There is a public notice component, so the guidelines recommend that you publish the protocol, and we also, an important component of the guidelines is that when you undertake data matching, that you do not create a new register or a new data set or a new database, that it's a temporary arrangement, and the main privacy implication there is that we recommend against long-term secondary uses of information. So you're collecting it for some unknown use later on. We recommend that you try to avoid that. And we also publish protocols on our website as well as exemption requests. And an important feature in the guidelines also is the recommendation that you undertake a privacy impact assessment before you commence data matching activity. Now, I'm just going to breeze through here because I know I have limited time. So I just want to get to some of the lessons learned from our data matching experience. So some of the things that we've noticed is to ensure that program protocols have sufficient detail and are up to date. A lot of the protocols we've seen seem to lack a bit of detail. If you feel like there are some sensitivities involved, we recommend that perhaps you have an internal version that would spell out all the necessary details for internal corporate knowledge, and also for quality assurance purposes, but then you have an external version that sort of redacts that a little bit. And if I was to really hammer one message home today, and that is the PIA process. Make sure you do a privacy impact assessment. Think about privacy by design before you start a data matching protocol. Because a lot of the issues that we see are agencies who haven't done that process, and then later on issues start occurring, and it's usually because they even haven't done a PIA, or they have done one but the recommendations haven't been taken on board. Thank you very much.